He wants 13 different opportunities to attack each and every incident.
And the truth is, you're dealing with humans, right? You're dealing with a jury who sees a guy accused of a terrible thing, and they're given this evidence of other things that they did. Well, welcome back to the pod. Here we are.
We're back.
Talking about the baseline killer, Mark Godot. We had our first episode to talk about that and went through really the facts of there's so many incidents and dates of offense and things like that, and we broke those down there. So if you didn't see that, that one, you're going to want to start there. Today, I'm going to break down.
Yeah, let's recap that. So really, the case was broken down into what the prosecutor ended up calling chapters, 13 chapters, 74 total criminal charges that were filed, including 9 murders. There were a total of 33 victims, and trial took 7.5 months, presided over by Warren Granville, now retired Superior Court judge, who still actually comes back to work on occasion.
We really like Judge Granville.
Judge Granville's a great guy. I've known Judge Granville since I was in law school. In fact, I clerked for him in law school during my first summer after my first year of law school.
Well,
so I got to know him, and one of the better trial judges.
Absolutely. I find him to be fair, a great temperament as well. Sometimes judges struggle with that, getting angry at people. It takes a lot of patience. But that's interesting that you clerked for him.
Yeah,
we know that.
One of the pieces of trivia from my past.
There you go.
So the prosecutor was Suzanne Cohen, and she's now a Superior Court judge, has been for a little while. We'll get into the defense lawyers here in a little bit. That was one of the claims that that Mr. Godot raised on his appeal, was that his lawyers were ineffective. So we'll talk about them a little bit more in detail. But yeah, just a massive trial, which is why we're doing this in 2 parts, right? We talked all about those facts. I agree with you. We'll encourage you, if you didn't listen to part 1, go back and do that. It's worth your time to understand what the facts are. But then now we're going to talk about some of the issues that were raised during the trial, and just as a practical matter. I mean, you've tried lots of cases. I've tried lots of cases. I honestly can't imagine being in trial for 7.5 months.
I mean, there's a lot of consideration to think about that. It had to be through the public defender's office.
That's
I
right.
mean, how a private attorney would do that, the costs would be astronomical in order to do that type of thing. And that's kind of interesting, too, where we're trying to wrangle with, the mass of what this case covers in a podcast very, very quickly. But think about that, too, is that the prosecutor and the court have to put together this case. And that's what we're talking about as far as the 13 chapters. Is that was really a function of the prosecutor saying, I'm proposing this as a way to break down the evidence for the jury. Mark Godot took issue with how that was done, and we'll talk about that.
And that's a great place to begin, actually. So imagine organizing, however many witnesses had to testify. You have, dozens and dozens of cops that had to testify. You have expert witnesses on both sides. You have civilian witnesses. Tons of people have to come in. And so by way of organization, the prosecutor said, they proposed, hey, Judge, we want to break this down into different chapters, 13 different chapters, so that the jury can kind of take this case in chunks because it's so large. Now, typically in a trial, the trial starts by, jury selection, of course, and then there's instructions that the judge reads to the jury once they're impaneled. The lawyers stand up and they each give an opening statement, and then the state has the burden of proof, so they present their witnesses first. The defense gets to cross-examine each of those witnesses, and then the state rests. If the defense wants to call witnesses, they can do that. The state then has an opportunity to call rebuttal witnesses if they want, and then at the end, the lawyers present their closing arguments. Here, instead of doing a single really long opening statement, the prosecutor was allowed to do 13 opening statements. I've never seen that.
Yeah, I've never heard of it either, and I thought maybe as we read through the appeals that there would be some questioning on that, but we'll talk about what the Arizona Supreme Court decided on that. And you think about how different that is for a defense and for everything like that. But, you can see the value, I guess, in it for the jury, right? And ultimately, that's what it came down to, is that the purpose of the trial is to help the jury understand the evidence and the case in order to make a fair determination. And so basically it was mini trials almost, right? Within each of those. There wasn't a closing, I believe, at the end of
That's
those.
right.
But there was, you gave us a great breakdown of how trial goes. But this one, the change was after each, there was an opening for just the first chapter, basically incident, broke that down. At the end of that, in order to mark the end of that and to mark the beginning of the new set of witnesses on a separate incident, a new opening statement. And again, we'll go through kind of some of the limitations to those opening statements,
Sure.
why it might not be unfair.
Right, and the prosecution gave opening statements for each of their chapters, and the defense was afforded an opportunity to do the same thing. Now, the defense in any criminal case, they don't have to offer an opening statement. Most of the time, you want to, because you want to share with the jury what you expect the evidence to show. And just to remind people, an opening statement is not argument.
Right.
It is a summary of what each side thinks the evidence will show as they present that evidence. So the prosecutor here gave chapter summaries at the beginning, and then the defense, they didn't present openings for every single chapter. They gave some, but they objected to the process. And ultimately, on the appeal, the Court of Appeals really kind of praised Judge Granville for the way he did this. They said, look, the rules allow the judge to create the environment for an effective trial, and the judge has discretion to do that. Here, given the length, the volume of the evidence, it was actually smart to allow the prosecutor to break this up into chapters. And so that was okay. It was something that he did raise on appeal.
Yeah.
The Court of Appeals says, or the Supreme Court says, no, that was fine.
Yeah, and that's something that, nerdy attorneys sometimes will go into. It is not an opening argument, which sometimes people say, right? It's an opening statement, and it's limited. If you go beyond the scope of what you're allowed to talk about there, the other side commonly will object, and it will be sustained if you're making argument about what the jury should conclude or how they should rule or decide on certain items. It's just to preview for them what the evidence you expect it to show. And why don't we start with, on that one, what was the actual argument that Godot's lawyers made on appeal to say, why was that inappropriate or unfair?
Sure. So their argument was that, you're giving the prosecutor basically too much leash to argue and represent their case. Now, Judge Granville, though, placed some limitations on the state. He said, they can only present in their opening what they expect the evidence to show. They can't summarize evidence in the previous chapters. They can't make any arguments. It's, hey, here's a snapshot of what you're going to see. And so because of those limitations and because of that sort of, restrictive environment that the trial judge imposed, again, Supreme Court says, yeah, that's fine. And I don't think it's something that you're going to see too much in other cases. I think it's something where, look, this is a unique set of facts. It's a big case, and it allowed, the state to present their case in an organized way. Now, as a defense attorney, the last thing I want in front of a jury, honestly, is organization. A good defense attorney, many times, thrives in an area of confusion where facts just don't seem to make sense, or you don't really understand what's going on. And I mean the jury. Defense loves that, because when there's confusion, there's doubt. The prosecution, of course, wants clarity. And so as a defense attorney, sure, I would object to those chapters, right?
Yeah, absolutely. And I think that was an interesting point that you made, that maybe this isn't something that we're going to see a lot. What I think makes it kind of lend itself to that is that it's a serial crime type of situation. And so that's what I wonder is, have other prosecutors in other areas or in Arizona for this is an interesting one, because it was first a serial rape type of situation where there was one trial, and then serial murder trial with other crimes in a second trial. Maybe that's a way that people will look at it and say, in a serial type of criminal situation, maybe this makes a lot of sense. I don't know.
Yeah, again, I think the rule is defer to the trial judge, and that puts a lot of pressure on a trial judge to get it right? Because if you don't get it right, the danger is that you've got to do the case all over again. And can you imagine if you're in trial for 7.5 months, doing a trial again? I mean, that's the last thing that you want to do.
It would have taken way longer.
Sure.
Right? If they had not done it that way, or, again, we want to get into some of the arguments. His argument from Godot was these should all be severed, which means
right. That's
should
a totally separate issue.
Yeah, you should. He was saying the state needs to try me on each of these with a separate jury and a separate case. Basically.
So let's focus in on that, right? You have, again, 74 counts, 13 different crime scenes, or 13 different areas where there were, assaults and murders and everything else. Arizona allows for crimes like that, sort of a crime spree, let's call it, to be joined. The rules say those can be joined in a single trial.
For like a common scheme. Or whatever.
Right. There's a number of different theories behind joinder. It's if they're the same character, or if they are part of a common scheme, or they give rise to some sort of pattern of behavior. So Godot says, Judge, I want 13 separate trials. And why would he ask for that? Well, because he wants 13 different juries. He wants 13 different opportunities to attack each and every incident. And if I'm his lawyer, heck yeah, that's what I want too.
And there's some basis to that too, right? I mean, there's a general concept in criminal law, and you'll talk more about this 404B situation that kind of is an exception to it, but where nobody should be considered guilty for one particular crime just because now there's evidence that they committed another crime at some point. It can, or that they had other acts or behavior that makes them giving them the propensity to commit this act, and so he must have committed this act.
Right, like the idea of, once a burglar, always a burglar, right? If you committed burglary once, then you're more likely to do it again. Therefore, evidence of the first burglary can come in the second case because you have this characteristic of somebody who commits burglary.
And that's not fair.
That logic is not allowed under the rules. Okay, so then how on earth is Godot's case able to be joined together? What authority does the court have to say we're going to try 13 different incidents all under one case with one juror?
Yeah, and again, you can see the problem if you're Godot, right? Where you say you're gonna present evidence of all, maybe on the first one they take a look and say, gosh, that's not real strong, but we also have some evidence that he also did this one. Okay, shoot, now we got a guy who's maybe doing multiple things. Third one, fourth one, fifth one. Doesn't that just wear a jury down? And at some point say, gosh, he's got to be guilty of some of this stuff.
Well, and it's that what they call a rub-off effect, right? There's so much evidence that's presented cumulatively to the same jury. They're going to be sitting there thinking, well, gosh, we got to find the guy guilty, right? Whereas if you do 13 different trials, you've got 13 different juries. Now they're just compartmentalized, and now they're just hearing a section of each one, and they're very limited about what they can consider. So the rules of procedure and evidence take that into account. So you have this limitation on character evidence, sort of this repetitive, behavior or characteristic like we talked about. That's not allowed. But what the rules say is court can join or leave together, keep together a case or multiple cases if it's part of a sort of a common scheme or plan, or if the crimes are so unique as to almost create a signature type crime where joinder then becomes important so that you can see that repeated pattern of behavior across all of the cases. And here, there wasn't a dispute about whether these crimes were committed.
Yeah, and this is different than the other cases we've looked at so far. Yeah.
Exactly.
Yeah.
Here, the defense is not saying people were not murdered or people were not sexually assaulted. They're saying you got the wrong guy.
Right.
Right?
Right.
Identity now is the issue. Okay. And so
it's a whodunit.
That's right.
Right? Versus the other ones we've looked at where we say we know who committed the killing, but they should be excused or not found guilty for XYZ reason.
Exactly.
This is a little different.
So you go back to our other podcast, like Harold Fish. No question Harold was the shooter. You go back to Scott Falater, murdered his wife. No question Scott did that. It was mental state, and for Fish, it was, self-defense. Here we have this string of murders and whatever. and we don't know who did it. Well, the state says, we know who did it. It was Marc Goudot, and here's how you know that Marc...
Because he was caught, not
right.
because anybody found him there at the scene, but based on an investigation and evidence. Yeah.
And so what the court then ultimately rules on is, you mentioned it earlier, there's this rule in evidence called 404. 404B says when identity is at issue, if there is a distinct sort of signature pattern of behavior that helps to identify that individual, then the jury can hear all of that evidence as proof of his identity.
Part of that, it's interesting because it's the same evidence that they would have heard that would be improper, but because it's being used for a different purpose.
That's
to
right.
identify the person rather than to say, because he did it before, he probably did it this time.
This is where understanding the facts of Goudot are important, okay? Because we went through each of those episodes in our last episode, and in each of them there was these kind of common threads, and I'll reiterate those, and this is what the court had acknowledged. Remember, in several instances, he said, hey, I just committed a robbery. I need to meet my buddy, or my buddy left me behind,
yeah.
Right? In several instances, he wore a disguise. Remember, and you brought this up, he had either wiped off the victims, or they had wiped, or he had wiped himself off to hide any sort of DNA or trace evidence. Crimes were committed in sort of secluded areas where he had the victims drive, or he gave them directions to go to certain places. He threatened to shoot them. Many of them described the same silver handgun, although no gun was found. That same common thread of seeing that handgun and then threatening to shoot them. So,
and also saying, don't look at me.
That's right.
Don't look at me was another thing he repeatedly said.
Correct. Super important point. And so the court looks across those crimes and says, look, we see these elements popping up, and they all kind of have those same characteristics, which therefore then point to an individual and identify him for us. Crazy.
Yeah,
right?
That's
what the rules allow for. We're not saying that, hey, Marc Goudot did it once, therefore he did it a bunch of times. No, they're saying this guy did these things in a pattern, and Marc Goudot, we believe, is the guy who committed that pattern of offenses.
And even if we can just show it really strongly on one or two of the events, because we can show that pattern, now you can use it for identity purposes and say, I think he was also the guy in that other.
It's a way to backdoor everything in so the jury hears one big trial.
And that was interesting, too, when there was a comment by the Supreme Court, Arizona Supreme Court, when he was talking about separating out or severing all the trials. And they said, really, it wouldn't have made a difference because of this, because of 404B and C, but B saying, even in those separate trials, they would have been able to use the evidence from the other acts because of this issue, because it worked with identity.
Yeah, and really that's what the rule is these cases have to be severed unless evidence of one crime would be what they call cross-admissible in another crime. And so the court does this full 404 analysis and says, hey, look, because identity is an issue, and these things are sort of signature, it's all coming in. And a jury can hear it. And so that's kind of a devastating blow to the defense when you say, hey, look, guess what? Yeah. You have one long trial and the jury's going to hear everything.
Right. And that's interesting. I mean, you deal with this a lot. It seems like you're kind of like the 404 guy. You're at the firm.
Well, I handle a lot of sex crimes.
Yeah.
And sex crimes cases often have 404 elements. There's actually a different rule of evidence called 404C, which was also analyzed in this case because, remember, there was evidence of sex assault and charges of sex assault. And so the court further analyzes this and says, well, under 404C, which is a different analysis, it's whether the person has this aberrant sexual propensity to commit a certain offense. It's also admissible for that reason. And so there's a few layers here that the court says, you know what, Goudot, you get one trial and one trial only.
Yeah. Is it fair to say that the ruling by the court on a 404 issue can win or lose a case for the defense?
Absolutely. Because you can go from what may be a weak case on its own, standing by itself, to now a very difficult case for the defense when you have certain other sort of mountains of evidence that come in and pile on. And now, as a defense attorney, you're kind of stuck.
Yeah, and the truth is, you're dealing with humans, right? You're dealing with a jury who sees a guy accused of a terrible thing, and they're given this evidence of other things that they did, right? Or that we believe they did, but they have to have pretty strong evidence, like, right? Clear and convincing evidence that they did the other thing. But they have to, they then hear this other stuff and they're told, don't use that evidence to say that because he did these other ones, he did this one. Only use the evidence for X, Y, and Z, right? Like, only use the evidence to prove identity.
Right.
A jury's still going to use it for that.
And it's a good point. I mean, the judge does give what they call a limiting instruction. They tell the jury, just like you said, look, don't use this to find him guilty, but just use this for purpose of identity or other, lawful reason. But the truth is, can you separate that out in someone's head?
Even if they're trying to do that legitimately, can we do that?
I think jurors honestly do their very best. And I appreciate the jury system that we have. But in a long and complex case like this, with so many instructions and so much evidence, it becomes overwhelming for anybody. Okay, and so for the prosecution, huge victory to get this thing joined. So I want to talk about his lawyers. Okay, we mentioned them in the beginning. They were Randall Craig and Roderick Carter, two great trial attorneys. They've been around the system for a long time. I know both of them. You know both of them. We see them in the halls of the courthouse, all the time. Over the span of the several years that it took for this case to go to trial, remember he was arrested in 2006. Didn't end up going to trial, I don't think, until 2011. So long time that there's this, lead up and build up to the trial. There were at least 4 occasions when Mr. Godot asked the court to fire Craig and Carter from his case. Now, they're private attorneys, but they are publicly appointed, meaning they have a public contract with the public defender's office to handle these types of cases. So they're public defenders for this case. Godot says, I'm not getting along with them. I want him fired.
And that was one of his bases for his appeal, right? Is to say, I tried to get rid of my lawyers. I didn't want these lawyers. They weren't effective for me. And so I didn't get a fair trial based on that. And like you said, Granville, and we're going to see this on all of his appeal issues pretty much, was incredibly thorough for all of those objections and anything that Godot had. Like you said, there were 4 occasions where he made this argument. So instead of just in court on a pretrial conference or some type of other hearing the complaint by the defendant, and the judge saying, I just don't find that sufficient, he actually held separate hearings for each of them and said, give me your reasoning. And he would give his reasoning. And in the end, at least on 3 of those occasions, Godot would kind of finish saying, look, no, they are good lawyers. We're doing good. We are communicating. I just want them to try harder, basically, is what it kind of boiled down to.
Right.
And the Supreme Court found that to be, hey, this issue was fully vetted, fully explored. And it was found that, you were okay keeping those lawyers. And then on the last one, I can't remember exactly what happened, but he was a little more adamant. But even at the end of that, kind of communicated that he could work with his lawyers and didn't want new ones because it was right before trial.
That's right.
Yeah.
So there's a couple of important principles at play here. Number one, and most importantly, is, as an accused facing, any sort of incarceration, but most especially the death penalty, you have a 6th Amendment right to counsel. Okay. And the court gave him counsel. You don't have a right to the counsel that you choose. Now, anybody can go out and hire their own lawyer, but that's not what is at issue. What's at issue here is court-appointed counsel. He has a right to that counsel. Counsel was court-appointed. And these are 2 very, very experienced lawyers, death-qualified lawyers.
That was the point I was going to make. Yeah.
And so they know what they're doing, and they're great trial lawyers.
And the point is, so that's actually a qualification you have to do a case like this. Like, you wouldn't be allowed to go in and do this, but especially as an appointed attorney, unless you have that, what we call death qualification, where you've shown that qualification to be eligible even to handle a capital case.
That's right. And so Mr. Craig and Mr. Carter, they're capital litigation lawyers. They've done this a long time. They're certainly qualified. So they meet that 6th Amendment hurdle. And what Godot says is, well, each of these times, he says, well, they're not working hard enough. He has a good relationship, and he, in fact, tells the court, I like them, but I want them to try harder.
He even says they're good trial lawyers.
Right.
Yeah.
So, the rule really, or the standard that the court looks at to relieve counsel is whether there's such a breakdown of communication and a breakdown of the lawyer-client relationship such that they can't work together anymore. And even though Godot raised these complaints, he never fully sort of fleshed out that issue, never made a claim that their relationship was so broken that they couldn't work together. And at the end of the day, Granville, I agree with you, he did the right thing. He held hearings specifically on these issues 4 times, and 4 times the court says, these guys are doing fine, keep at it. And, to their credit, they handled a very lengthy case, not only the trial, but the lead up to the trial. Years they worked on this case. And then for trial for 7.5 months. So, he doesn't get to choose his lawyer, but, he did get, the services of 2 outstanding lawyers.
And to your point on that they don't necessarily get to choose their lawyer, we kind of see this in court quite a bit, right? Where how court works a lot of times, we're in these pretrial conferences, we're set at, say, 1:30 in the afternoon at the same time as 20 other cases. So you'll have multiple defendants that are there with their public defenders. And how common is it for them to say, my public defender's not working for me, this relationship is broken? And even then, most of the time I see the judges in those situations say, you have a right to a lawyer. You don't have a right to the lawyer you get to choose if it's being appointed, which is a tough. I get that.
True, except it is the safe route would be to appoint a new lawyer,
right? Because like you're saying, there is a criteria to say if it comes back later that relationship was so toxic and they couldn't even work together, potentially that's a basis.
But the danger is, and this is what Granville had to balance, is you've got this massive case, guys who had years invested in the investigation. Now you're going to swap lawyers? So we're not going to do the trial 4 or 5 years later. We're going to do it 6 or 7 years later because this new set of lawyers has to get up to speed, and who's to say he's not going to be upset with them? I mean, at some point you do have to draw a line. And Godot's issue, again, he never fully made the claim that the lawyer-client relationship was so broken that he couldn't fix it. And so he goes to trial. One other thing that I wanted to raise, well, we know there's a single trial. We know he's got these 2 lawyers who are handling his case. The state begins to present their evidence. And remember, the defense here is ID, right? Let's talk about ID for a little while, because there were some serious problems with the state's ability to prove identification.
At least through eyewitness identification.
Eyewitness identification. Now, we'll get into the DNA in a little bit, but as each witness testifies, they're going to go on the witness stand, and many of them are going to be asked by the prosecutor, do you see the person in the room who committed this offense? You laugh because you've done this a million times.
Yeah.
Do you see the person? Okay, now, again, having tried lots of cases, how do you not pick the guy who's sitting next to the defense lawyer at the defense table?
Yeah, and this guy had 2 defense lawyers in their suits on either side of him, on the defense side of the table that has a little name tag that says defense. Right.
It seems a little silly or hollow to say, hey, now pick the guy sitting right over there.
Right.
Who else are they going to pick?
Right.
Okay.
Although I do have a fun story about that.
Go ahead.
One time, it was an attempted murder case.
Yeah.
I was actually clerking for a judge at the time, so I was in law school, and it was an attempted murder. And the witness is up on the stand, the main witness.
Yeah.
I mean, this is the identification witness.
Yeah.
And they say that, And so this is the one time I actually didn't see them read all the context cues in the courtroom and say, obviously it's this dude sitting right here.
Right.
And they say, do you see the defendant in the room?
Yeah.
And he just looks around at everybody forever. And he goes, can I get up and walk around the courtroom?
Sure.
Gets up, walks around the courtroom, and eventually says, I think it's that guy right there. And that was a pretty strong win for the defense on that one.
Prosecution is sweating at that point. Aren't they? They're just like, oh gosh, this picket.
Oh, it was so great.
Right. Can I tell a story?
Sure.
So when I was a prosecutor years ago, defendant in the case was wearing this tan shirt. And the defense attorney had kind of pulled a move where
he wore the same.
He planted in the audience a guy wearing a tan shirt. And so when the victim on the stand says it's the guy wearing the tan shirt, And the judge says, yes, I see that the record will reflect that the victim has identified the defendant. On cross-examination, then the defense says, are you talking about this guy in the tan shirt or the guy in the back in the tan shirt? So he created this element of confusion. I thought it was kind of a stupid move by the defense to do something corny like that.
Yeah.
And, ultimately I won. But, ID, that moment in trial is really important. And so think about
what you see on TV, right? It's where you say, do you see that man in the courtroom? Right.
Full of drama, not nearly as much drama as what you see on TV, but it is an important moment where victims will say, that's my accuser.
Yeah.
That's the guy that did this to me.
And that's why I get so frustrated with it, is because and they argue this, and I don't dispute this argument from the defense, is that it's suggestive, right? But it doesn't mean that it overturns the case.
Let's get into suggestibility, because that's the important part here. A number of these victims, pre-trial, either were unable or failed to make a identification of Godot before trial. They gave descriptions, and those descriptions varied. They had some very similar characteristics. Black male, athletic build, whatever height. One of them described his disguise, which was the bucket hat and the wig, which ultimately became the drawing that was put out to the media. So they gave descriptions, and then a number of them were presented with photo lineups later on, and they didn't all pick out the guy in the photo lineup.
And that's such a vital part of an identification case, right? Is where first you get the description.
Right.
And that's where suggestibility kind of comes in, as far as the police having to make sure they do this in a way that is appropriate and not suggestive, right?
Yeah, and one of the most common ways that police will do this sort of pretrial identification is they'll create what we call a 6-pack, 6 photos of similar-looking people, similar characteristics. There won't be any names on those photos. They're just numbered. The officer reads an admonition that says, I'm going to show you 6 photos. The person who did this may or may not be in that group. I'm not directing you to pick any one of them, but if you see the guy who did this, point to him. Now, I'm paraphrasing, but that's generally what they say.
Yeah, and how they say it is vital, right? Because
and there's a specific instruction that they read. Again, I'm paraphrasing. Law enforcement has a specific advisement that they read, and they're not to steer the person to pick a particular person. Now, in this case, a number of people were unable to make that ID, pre-trial. And before his arrest, police tried to get once they figured out it was Godot as their suspect, they tried to make sure that anybody who may testify had an opportunity to make that ID on a photo lineup or otherwise. One of them did a voice identification. They had 6 different people, including Godot, say this same phrase, on a recording, and she had to pick out the voice. She actually did. She got the right person. She got Godot's voice. But, a number of them could not ID him pre-trial. And then what happens?
Magically?
Well, the media then releases the drawing, right? The police sketch. And then after Godot is arrested, guess whose picture's in the news every other day?
Yep.
Godot, right? One of the victims actually went to court, a pretrial hearing, where she saw Godot in the courtroom before trial.
Okay, kind of gets back to, how are the police not allowed to do an identification, right?
Sure.
Like there's some that are disfavored. I'm not saying they're not allowed, but things like a one-person show up, right? Where they basically say, I don't know, the common scenario is where it's still on the scene and they drive them past and the guy is cuffed against the police car, right? And they say, is that the guy?
Right, the guy in handcuffs standing on the police
that we just arrested for the crime.
Is this the one that did it? Who are they going to pick?
Right.
Right? I mean, use your common sense.
And so this kind of, I guess, harkens to that, right? Where you're creating, it's actually a little bit different, right? Where you're creating kind of a connection for them in their brain of, this must be the person, and I'm seeing their face, and they're being associated as the person who committed these offenses, and it kind of creates what they call a tainting the identification.
So major issue on his appeal was, Judge, you shouldn't have allowed, or Supreme Court, the trial judge, Judge Granville, should not have allowed each of these victims to point to Godot in trial and say, that's the guy. Why? Because their in-trial identification was tainted or affected by something that happened prior to them pointing him out in trial, right? So after the crime occurs, they give a description. Perhaps they do or they don't ID him in the photo lineup. And then there's all the instances where they see him before the trial, but after the ID, after he's already been arrested. And now they're saying that's the guy. It's sort of this sort of confirmation bias, right? Where now you say, well, that's the guy who did it because that's the guy they arrested.
Right.
Now, the Supreme Court resolves this issue by saying, and again, this was a smart move by the prosecutor.
And by Granville.
But the prosecutor would have asked a question and did ask a question to each of these people. Why are you saying that that is the guy?
How do you know?
How do you know that that's the guy? And each of them in their testimony said, because I remember his face or something to that
From
effect.
that day, I'll
never forget it. And I saw him and that look in his eye or whatever it is that they said, that's the guy. Okay.
And then Granville, not to cut you off, you were going to keep going on that. Granville, he didn't just allow it to happen either, right? He actually held hearings for each of these outside the presence of the jury called Deserault.
That's right.
Hearings, right?
Right. So in Arizona, it's an ID hearing, what we call it. It's based off a case that goes by the name of Deserault, State versus Deserault, I think. And so you have this pre-hearing before trial, outside of the presence of the jury, where you scrutinize the identification procedure. And this is where the prosecutor, has to make her case that this is not unduly affected by whatever exposure to him came later. Instead, it is because they believe it and because that's the guy. And the Supreme Court each time with each victim says, and they remembered him, and that's what is the basis for their testimony. Now, who's the judge of that credibility?
Right.
That's the jury. Jury gets to decide, do we believe that or do we not believe that?
Yeah, and I want to clarify one thing where I'm saying that Judge Granville was smart to do it this way. I'm looking at it from a perspective of he didn't get overturned by the Supreme Court. But really, ultimately, the base for that is that it's because it was fair, right? That he did consider that issue and that potential problem, and he vetted it out outside of the presence of the jury before they say you can't unring the bell once they hear it, and that he explored that to make sure that there was a decent basis before putting that testimony on the record.
Yeah, and then when it comes in as evidence in trial, the jury has to decide, do we believe that evidence or do we not? And of course, if I'm his defense lawyer, I'm going to say the other thing that the Supreme Court said was the defense had an opportunity to thoroughly cross-examine each victim. Now, you can bet that in my playbook as a defense lawyer, I'm going to talk about that artist rendering. I'm going to talk about all the times he appeared on TV and you had an opportunity to see him and now you're pointing him out. I'm going to dig into that victim and say, assert the idea or plant the idea in the jury's mind that they're only pointing to Godot because of something that happened later, not because they remember him at the scene.
Right. And I think an interesting point is that even if a witness is saying, no, none of those things affected me, they might just be mistaken, right? I mean, how do we know what affected our memory of why I'm identifying this person?
You could dive down the memory and reliability rabbit hole for ages. I mean, people make a career out of studying memory, and I don't claim to be a memory expert. I don't think you do either. It's something that we have to deal with as trial lawyers, but it's a topic unto itself, really. And a jury of people from the community are tasked with, hey, do you believe what they're saying?
Right. And there's this common question that we ask as defense attorneys when the first time they were shown a six-pack and they didn't identify him, then here we are I don't know, what would it take, 5 years to try the case? Here we are 4 years later, and now you're identifying him. You just ask the question, do you think your memory was better, 3 months after this happened, or now 5 years later, about what happened? But yeah, I'm assuming they had the opportunity to make that cross-examination question.
Of course, and that's where the court, the higher court left it, and they said, look, it's something that the jury considered. The judge did it in the right way. Let's keep going on the topic of ID, because one of the major ID tools that the prosecutor used was the DNA evidence.
It's a strong one.
Yeah. So on the topic of DNA, one of the sisters who was sexually assaulted in incident number 3 or chapter 3, police found DNA on her breast. eventually, through some testing, they were able to find or to able to link that back to Godot. Now, some testing was done before his arrest, and then other testing was done after his arrest. And there were a number of DNA samples that came back to him. Not every incident involved, DNA or had DNA evidence, but many did. And one of the issues was that sometimes the DNA particles that are left behind are so small that the source material is consumed or used up in testing. In pretrial, like before he's charged, before he's arrested, that's not as important as it is if he has counsel. And counsel, after he's arrested, made a motion that says, Judge, we want to be present, we want to observe, we want to be a part of this analysis if it's going to consume it, because we don't have another opportunity to take our own sample and test it ourselves. And so there was ongoing litigation about the defense wanted to be able to observe and essentially monitor this DNA procedure that was being done, and the court didn't allow it. Basically, they said for two reasons. The judge said for two reasons. One, there's no real allegation of bad faith on the part of the state or any reason to believe that they were doing anything improper. Plus, when they analyze DNA, there's going to be notes and other details that a defense expert can go back and review, right? I recognize that it's not as good as doing the testing yourself, which is what the defense wanted, but the problem is there's not enough for two people to test it. It gets consumed during the analysis, and so, the state gets it. What do you think of that?
I don't know. I have a hard time with that,
Yeah.
Good faith thing.
Sure.
It seems to be kind of a fallback for a lot of courts, is to say, look, you can't show me any evidence of why we should believe that this testing was done improperly or any false, Well, that's why we need to observe it, right?
Sure.
How do I gain that evidence of it, and what's the harm in me having somebody there or requiring it to be videoed or whatever for me to see it? So I that's always kind of a frustrating circular argument for me, because we see that a lot in a lot of different kind of situations where they say, well, yeah, you might be right about this, but we have no evidence of bad faith or bad acting. So until you can show me that evidence, and the reason we don't have it is, either it wasn't done with bad faith or there's no possible way for me to prove it because you're not allowing me to have access to it.
Yeah, I agree with you. That's one reason why in a DUI case, for instance, officers take 2 tubes of blood, one for the prosecution and then one if the defense wants to retest it. Now here, it's not that same type of thing because they're going after the fact, trying to look for any sort of trace amounts of material that they could gather and use in DNA to do DNA analysis. And so the state is sort of left with whatever it is that they were able to collect, but not enough material that it could be tested by the defense and the prosecution. So the judge says, look, prosecution gets it. And, the Supreme Court upholds it. They said that procedure is fine.
And I'm not saying it's wrong.
Yeah.
And there's a lot about this
It's
stuff
frustrating
where,
as a defense lawyer.
where I vent my frustrations,
Right.
but I also recognize it's not necessarily a basis for overturning a conviction or saying that it was wrongly decided by the judge.
Right. Another area that Godot attacked during the trial was sort of the prosecution style, okay? Remember in those 13 opening statements, the state was able to give a summary of what their evidence would show. One of the things that the prosecutor did was kind of name call Godot, called him a wolf in sheep's clothing. He's on the hunt. He's on the prowl. He's going to attack.
Right.
Monster. She did that in her opening, and the Supreme Court actually calls her out and says, you can't do that. And the term for that is prosecutorial misconduct. We talked about that a little bit when we discussed Juan Martinez a few weeks ago. You're not supposed to do that. An opening statement is just that. It's a summary of what the facts are. It's not an opportunity to make argument. Now, the Supreme Court does say, hey, when she said that in closing argument, when she is summarizing evidence and making argument as to why he's guilty, she has much more latitude to say he's a wolf, he's a predator, he's a hunter, he's in sheep's clothing with his disguise. And so the court kind of gently reminds Cohen that she can't do that, not in opening, but she can in closing. Now, Godot argues, hey, my case should be overturned because the prosecutor committed this misconduct. But the Supreme Court found that the misconduct was not so pervasive that it affected the outcome of the trial. Kind of wagged the finger at the prosecutor saying, hey, don't do that, but it's not bad enough.
And that's pretty common.
Yeah.
Right. Even in some of the other cases that we've looked at where
Sure.
it was, pretty bad misconduct, is that it's a two-part analysis, right, done by the Supreme Court or the Court of Appeals that says, was there misconduct? And is there, real strong reason to believe that that could have changed the outcome of the case?
Now, we're not...
Or the jury.
Right. And we're not covering every possible argument that Godot made on his appeal. There's too many.
Yes.
We've covered the major ones. One of the final ones that I want to talk about is, and sort of the procedure. So in a capital case, there is what they call the guilt phase, right? Whether the jury finds that he's guilty of these offenses. And then if they find him guilty of any offenses, especially of the murders, then there's a separate phase called the penalty phase. That's where the jury then listens to aggravating factors or aggravation evidence. And then the defense can also present mitigating evidence, things in his favor. And at the end of the day, the jury is tasked with, deciding, does he get the death penalty or not? And they have to weigh the aggravation against the mitigation and determine should the death penalty be imposed.
Yeah, it's interesting because there's commonly an aggravation phase, I guess, or a sentencing phase in a lot of different types of cases, but it's different in a capital case where it's the jury making that decision on whether it's death or not, right?
That's right. And so the aggravator, there are specific facts that the jury has to find. And one of those in death penalty cases is whether the murder was especially cruel, heinous, or depraved. Remember here, there are 9 murders. This may sound sort of callous, but not every murder is bad enough to get the death penalty. It has to be kind of next level. And here, the state had to prove that level of especially heinous, cruel, or depraved. And what that means, and I'll read this directly from the court, is that the victim consciously experienced physical or mental pain before death, and the defendant knew that suffering would occur. So what the court did is they go through each of these homicides, and in each one, they point out facts where it wasn't just a single shot to the head from behind, and the person didn't know that they were being killed. It was sometimes multiple shots, kidnapping, taking them to another area, where they had this sort of impending doom that they knew that they were going to be killed.
Or just scared of something.
Scared.
He's having them drive him around. One of them was a mother and a minor daughter, and he sexually assaults the minor daughter while the mom is there, things like that.
Right. So the jury ultimately does, well, first they convict him of 67 of the 74 counts, including the 9 murders. So they then move to this aggravation phase. The state is then able to prove this aggravator of especially cruel, heinous, and depraved by the state presenting, facts of each of, how these murders were committed and how might a person suffer before death. I mean, it's awful even just to think about those things. But the jury had to make that decision. So the jury does then find that these aggravators exist as to those murders, making them eligible for the death penalty. But then comes the mitigation phase. And that's where this case took a turn. It took a turn.
Really interesting, because during that mitigation phase, it's really a balancing test, right? That the jury has to make and say, I'm balancing all the bad things about this case, and I'm balancing any good things about the defendant or about the case, and I'm making that decision. And in capital cases, it is an extended process where they're bringing in character witnesses, expert witnesses, as far as trauma in his past, or reasons to say that there's mitigation for him, and it's pretty extended generally.
Yeah, and so the defense has the burden then of putting on family, friends, experts to show that this person should not get the death penalty. Maybe they were abused as a child. Maybe there's these horrific things that they went through, whatever. Godot's lawyers presented one expert who, talked about how he was reformed, and he wouldn't be a danger in prison, and all of these things. And then all of a sudden, Godot says, "I don't want to do this anymore." He didn't even want to be in the trial. He wanted to just go back to his cell and let the trial finish on his own, not present mitigation, not be present. And the court kind of, went back and forth. I'm sure Judge Granville probably was, his patience was probably running pretty thin after such a long ordeal. But, ultimately found that Godot didn't want to present any more mitigation. And they called a stop.
And again,
to it.
He did that very carefully. He did it very thoroughly, where I think there were multiple hearings where he gave him the opportunity, explained why this mitigation is important, gave him the opportunity to still do it, gave his lawyers the opportunity to explain to him why they need to do it. And ultimately, it's his trial. It's his opportunity to do that mitigation, and the judge allowed him to knowingly waive that opportunity.
So now no mitigation basically gets presented on Godot's behalf. The jury has already found the aggravator, and they've heard, months-long testimony of these horrible things, and they impose the death penalty, right? 9 death sentences. And then, he takes his case up on appeal to the Arizona Supreme Court. Supreme Court affirms it. He did appeal to the U.S. Supreme Court. They denied review of his case. And so Mark Godot currently sits on death row in Arizona. I don't know the extent of any further appeals. There may be federal habeas or other remedies that he may seek through, other forms of review. But, horrific case that ended ultimately, in 2016. That's when the Supreme Court of Arizona issued their opinion in Godot, and that's where he sits.
Absolutely. It's a lot of lessons, I guess, and it's an interesting, from a trial lawyer's perspective, an interesting kind of process that it went through. Ultimately found guilty, and these juries are in a tough position.
Yeah.
To make that decision on whether or not it's life or death for somebody. Ultimately found that was the appropriate sentence for him. So it's tough.
And remember, these crimes took place in 2005 to 2006. His trial took place, in 2011, and then his appeal was final in 2016. So 11 years, really, from start to finish. And he hasn't been executed. I mean, he's going to be on death row for who knows how long. But 11 years to get through that kind of initial phase of court hearings. And again, it closes an important chapter, I think, in Arizona history. We talked about that time frame, how scary it was. Godot now is the guy. And, at some point, that sentence may be carried out. Well, thank you.
Thank you.
Appreciate you, Ryan.
Appreciate it.
Okay.